Search is incident to a lawful arrest. Search incident to a lawful arrest, commonly known as search incident to arrest SITA or the Chimel rule, is a U.S. legal principle that allows police to perform a warrantless search of an arrested person and the area within the arrestee's immediate control in the interest of officer safety, the prevention of escape, and the preservation of evidence. In most cases, a search warrant pursuant to the Fourth Amendment is required to perform a lawful search. An exception to this requirement is SITA. Related case law. 1940s. In Harris v. United States 1947, the United States Supreme Court held that a law enforcement officer was permitted to perform a warrantless search during or immediately after a lawful arrest of the arrestee and their premises, regardless of what the arrest was for. 1950s. In United States v. Rabinovitz 1950, the court narrowed its ruling to searches of the area within the arrestee's immediate control. 1960s. In Chimel v. California in 1969, the court further limited the exception to the person arrested and the area within their immediate control in order to remove any weapons that the arrestee might seek to use in order to resist arrest or effect his escape and to prevent. 1970s. United States v. Robinson 1973, the U.S. Supreme Court held that, in the case of a lawful custodial arrest, a full search of the person is not only an exception to the warrant requirement of the Fourth Amendment, but is also a reasonable search under that amendment. 1990s. Maryland v. Huey 1990, the U.S. Supreme Court held that the Fourth Amendment permits a properly limited protective sweep in conjunction with an in-home arrest when the searching officer possesses a reasonable belief based on specific and articulable facts that the 2000s. Arizona v. Gant 2009, the U.S. Supreme Court ruled that law enforcement officers can search automobiles following arrest only if the person arrested could have accessed his car at the time of the search. In other words, if the person arrested could conceivably reach into his car for a weapon, then a search based on officer safety is permitted. Otherwise, the old practice of allowing officers to search a car incident to arrest is no longer allowed, unless the police have reason to believe the vehicle contains evidence of the offense of arrest. 2010s.